Start. Assuming that actual prejudice is necessary, then as the only charge against the appellant being one under section 302 read with section 34, and that having failed due to the acquittal of the co-accused and the appellant having successfully shown that there was no common intention as contemplated by section 34 of the Indian Penal Code, prejudice is bound to occur due to his conviction under section 302 simpliciter, with which he was never charged. In any event, the offence committed in the case, even though the blow was struck on the head, could never be murder, as even the medical evidence showed that the bead injury was likely to result in fatal consequences. The offence committed would either be one of grievous hurt under section 325 or alternatively it is covered by exception 4 to section 300 and punishable under the second part of section 304. B. Sane and I.N. Shroff. From the respondent, the word illegality, which is frequently used in the judgments, is nowhere defined in the Code of Criminal Procedure. This word had been used by the judges to convey that the trial has been irregular and the irregularity is not curable under the provisions of the code. The word has been used in three senses, namely A. In cases where the trial and conviction are ab initio void due to some inherent defect which goes to the root and is by itself enough to vitiate the trial, as in cases of lack of jurisdiction, example, where section 197 of the code has not been complied with. B. In cases where a mandatory prohibition of the code has been disregarded and it is apparent from the provision itself that, having regard to its objects and purposes, such disregard is bound to lead to prejudice. C. In a more popular sense, that is, in respect of a particular case or cases where, having regard to the facts and circumstances, whether it be due to prejudice or otherwise, the conviction cannot be sustained, proceeding on the basis that an offence under section 302 read with section 149 is a distinct and separate offence from an offence under section 302. The question is whether, in the absence of actual prejudice, the conviction of a person of the latter offence, when he is only charged with the former, is illegal. The answer depends on the determination as to whether the failure to frame a charge is such a disregard of the mandatory provisions of the code so as to lead to the conclusion that prejudice must have been caused. In N.A. Subramania Iyer versus King Emperor (1901-28 IA 257 the decision was based on the facts of the case in which actual prejudice was caused. In any event, that decision stands modified by the decisions of the Privy Council in the latter cases. It is clear from those decisions that every breach of a mandatory provision is not such as would ipso facto vitiate a trial. If one looks at the relevant sections, the object behind the enactment of those provisions and the intention of the legislature It is clear that the framing of a charge, though mandatory, is not of a vital nature. See sections 210, 254, 271, 221, 222, 223, 225, 226, 227, 232 and 535. All that the code contemplates is that an accused person must in fact receive notice of what B is being tried for. When a person is charged with an offence under section 302 read with section 149 of the Indian Penal Code, there is no objection to his being convicted under section 302 without a charge being framed, if it appears from the evidence that he has committed the actual murder, and it appears from the record that either by the trend of cross-examination or by reason of questions being put to him under section 342, he understood that he was actually being tried for murder. In bracket, see Karnail Singh and another versus the state of Punjab in bracket 1954 8 CR 904 bracket out, and Lachman Singh and others versus the state in bracket 1952 SCR 839. A case of this nature may even be covered by the provisions of section 237 of the Code of Criminal Procedure. The cases of Nanak Chand versus State of Punjab in bracket 1955 1 SCR 1201 and Suraj Pal versus State of UP in bracket 1955 1 SCR 1332 do not lay down the proposition that even in the absence of prejudice, conviction of a person under section 302 who is charged with an offence under section 302 read with section 149 would be ipso facto illegal. Whatever view the court takes in respect of a conviction under section 302, when a person is charged with section 302 read with section 149, it is quite clear that a person can be validly convicted of murder when he is charged. Full stop, over.